Welcome to Inherently Distinctive.
Welcome back to Inherently Distinctive with Mark Goodman. Mark is a Nevada-based intellectual property attorney who helps innovators and entrepreneurs protect what sets their business apart. I'm Heidi Mack, and today we're talking about an important decision: whether or not you should patent your innovation or keep it a trade secret. Mark's going to break down the differences, when one path makes more sense than the other, and how to make a smart decision for your business and your IP. This episode is Patent or Trade Secret: Choosing the Right Protection for Your Innovation. Welcome back, Mark. Thank you for joining us.
Okay, I'm ready to rock here.
Awesome. You have all the knowledge. So, Mark, let's start it off. Can you start by explaining the key difference between a patent and a trade secret from a legal standpoint?
Okay, so um, both patents and trade secrets can be used to protect inventions or other types of innovation. Um, Now, they operate completely differently. So, a patent, as most of us understand, but just to review some basics, right, is something that's granted to you by the government, right? You prepare and file this very complicated application that's usually at least like 20 or 30 pages of stuff, including drawings and claims, written description, detailed written description of the invention, all of this, right? You file it, you then have this big process. We just talked about office actions last episode, right? You go through that whole process, and eventually, hopefully, you get this patent in your hand, which gives you the right to be the exclusive seller of this innovation for 20 years, basically, right? Um, Now, trade secret, on the other hand, there's no filing with the government or anybody, right? Trade secrets is something the law gives you kind of automatically, you could say. Um, but you have to, in order to maintain a trade secret, you have to take certain steps, right? You have to do basically. There's two elements to establishing a trade secret. One is that, which is usually the easy part, which is you have to have something that is of economic value, but by being not known to others. Okay. Um, and that can be anything, though. So just because it doesn't have to be like a new invention necessarily, right? That's the nice thing about trade secrets. You don't have to prove to anybody that your invention is novel, right? It just has to be economically valuable by not being known to others, right? If I have the most famous trade secret probably is the formula for Coca-Cola, right? Um, you have this formula, you know how to make this. Other people don't. They've tried to copy it. They can't seem to copy it exactly, right? And so there's huge economic value by the fact that this is a secret, right? Another one that we deal with in our business today with a podcast a lot, the algorithms that Google uses
Mhm.
are a closely guarded trade secret, to my understanding, right? Like, and they can change and so forth, right? That's the other thing with trade secrets; they can kind of change and shift, right? And so, I think when we're making the decision on whether we want to go the trade secret route and the patent route, and incidentally, it is a decision, right? Because patents are public documents, so obviously you can't patent something and have a trade secret in it, right? Because it's not a secret; it's published, obviously. So and even there's even patent principles that even extend beyond that a little bit. There's something called the best mode requirement. This is something that comes up in patent law, usually comes up in litigation more than it does when we're filing. But you have to describe the best mode known to the inventor at the time of practicing the invention in your application, right? And so you can't even hide that. You can't oh, I'm going to get a patent on this, but I'm going to have a secret on how we really implement it best. Can't do that, right? So it really is a decision. And the most important factor is going to be, is this technology capable of being easily reverse engineered? Because trade secrets do not protect against reverse engineering.
Mm.
So if you and I go to the store and buy a bottle of Coke and take it home to our lab and somehow figure out exactly what this formula must have been because we are that brilliant scientists or
That's
something,
right.
totally fine to do that, right? That is completely legal. We can do that, no problem. There's nothing they can do about it. Now, we can't call it Coca-Cola or use their something similar to their logo or get in trouble on
Yeah.
trademark, right? So there's that. But we can copy the technology of the formula if we want. Right now, if on the other hand, what trademark does protect against is like if we infiltrate the lab somehow and get access to the formula, or let's say we know someone at the Coca-Cola company that has access to the formula and we pay them off or something. Well, that's a trade secret misappropriation, right?
Yeah.
And those types of actions honestly can get you in trouble criminally as well as civilly. So don't get
I thought
yourself
so.
into that, please.
There's lots of
Right?
movies about that.
I mean, that's like something you see in the movies, right? But
Yeah.
yeah, like we infiltrated the vault and we got the formula, and now
Yeah.
we can compete with them, right?
Yeah.
No, don't do that, right? But that you can't do, right? That can get you in big trouble. But reverse engineering is totally fine. So most people, if your invention is some sort of mechanical contraption of some kind, you
Mhm.
have to go the patent route, right? There's just no way because any reasonably smart engineer is going to be able to buy your product fair and square, take it apart, figure out exactly how it works, and copy it. Right. So you have to really go the patent route. But if your invention is in some sort of formula, like sometimes I have people, this is an incredibly new recipe for like cookies. I mean, probably better to keep it as a trade secret, right? If you just make these cookies, you can't really deconstruct a cookie and necessarily know, well, I needed to bake it at 275 for 12 minutes. You don't know those things, right?
Mhm.
Just by taking apart a cookie. So it might make sense. So some advantages of trade secrets can last forever, right? If Coca-Cola had patented the formula, which they could have done, that patent, I believe, would have expired in 1903. Then it would be public domain at that point.
Wow.
So much smarter move to keep it as a trade secret, right? Same thing
Mhm.
if Google patented its algorithm in, let's say, 2003. I know it changes, but at least the basic algorithm would be public domain now. Uh,
Wow.
so those are things to consider. So that's the main thing to be thinking about. Some other factors talking about trade secret and patents. Nice
Mhm.
thing about trade secrets is that they can cover all kinds of things. It doesn't have to be like an invention, like things like marketing plans or just your business strategies. Those can be trade secrets, right? Whereas, like, you're not going to get a patent, generally speaking, on that kind of a thing. That's beyond the scope of today's podcast, but generally can't get that. Some business methods you can, but just like, oh, I'm gonna reach out to this. Say you had a customer list or a list of people that would be good marketing targets. That could be a trade secret. That obviously can't be patented. So, let's see.
Yeah, no, you've given us quite a bit of information. I love that you've given us like the differences, what might fit better for certain types of inventions and industries. So, what kind of internal policies or security measures does a business need in place to actually maintain, say, a trade secret?
So good point. Good point to bring up. That was actually probably where I was trying to go and couldn't think of it. Right? Is that
Yeah.
to get a trade secret? There's two elements, like we said. It's got to have economic value from not being known to others. Second item, and we didn't finish that loop, is it has to be the subject of reasonable efforts to keep it secret. Okay. So that's the legal standard, right? Now, practically, what do you want to do? Well, first of all, obviously, you can't publish it, right? If you publish it on your website or something, well, then it's no longer trade secret. Completely is gone, right? If you intentionally did, right? If someone steals it and publishes it, the court could order that be all taken down and try to keep the secret as much as possible, right? Um, but if you just intentionally let people know it's not a secret, so you have to keep it secret. Now, the most important thing usually is to make sure that everybody that you let in on the secret is under a confidentiality obligation of some kind. Usually that means either they're, let's say, professionals like your lawyers or accountants or something. Generally, they're automatically going to be under that confidentiality obligation. But if it's just anybody else, you want to at least have them sign a non-disclosure agreement prior to the time you let them in on the secret sauce, right? And that's really the best practice, right? And then you also have to be careful about, like, well, okay, so those people under the confidential, but what if they start doing things that they need to have some other employees at the company? Got to figure out who's you want to put everybody in the company and in on a need to know basis as much as possible with respect to these secrets, right? Because even though it's great to have the confidentiality agreement and you can enforce it in court, you don't want that, right? So sometimes the better thing is just physically keeping this thing secret from as many people as possible and only letting people in on it that really need to have that information to do their jobs and make things happen for you, right? So those are the two main things, as well. Physical security, right? And this involves in the modern day both physical security, like maybe you have it in a vault, right? I'm not saying most businesses have to do that, but certainly I think the Coca-Cola formula is still in a vault or something like that. I
That's
don't really
amazing.
for sure, but I think it is. And so there may be, physical, making sure that your, offices are locked, and, you know, that something like that would be kept in, if it was written down in a locked cabinet. And then, of course, also you want to have really good IT help to make sure that it's encrypted, and in terms of the digital content is, locked down so that people can't hack into it. And that it isn't just intercepted. You don't want to send it over unencrypted email, that type of thing. Ideally, right? And again, if somebody were to intercept an email, that would be trademark misappropriation, right? But then you have to deal with a lawsuit or finding these people. It's going to be a giant headache, when if you'd just had better security measures, you wouldn't have that. So even though legally sending it on an unsecured or a normal email, I would say, right? Most emails not encrypted end to end, right? Uh, isn't going to destroy your trade secret. It's just maybe not the best practice, depending on how competitive your industry is, who could be snooping around, that kind of thing. Um,
I mean, that's what you're saying. Like, so yeah, if you're talking about protection, can they lose their rights if they're not like properly protecting it?
yeah, and it's you absolutely could, right? If you just kind of are real loosey goosey about your secret, eventually the court could say you haven't taken reasonable measures to keep this secret. It's therefore not a secret, and therefore it's not a trade secret, and therefore you have no rights. And that would be determined in court when you're trying to enforce it, right? There isn't a governing body of trade secrets, really. Um, and it's mostly state law too. So you have whichever state court you're in, gonna make a determination, right? But it's just the general guidelines, non-disclosure agreement, good, both physical secrecy and cyber secrecy. If you do those three things, I think you're going to be fine in terms of the trade secret.
So say you've got this trade secret that you have and you're keeping it hush hush, but what it happens if someone else independently like invents the same thing per se?
Yeah, that's what we talked about before, right?
Yeah.
They if they independently invent the same thing, they're free to do that. Trade secret does not. It's just really what trade secret, where it developed, was not so much to protect innovation and further innovation, right? The stated purpose of, let's say, patent and copyright law is to allow for the progress of technology and art into the future. It even says something like that in the Constitution, right? Whereas the trade secret developed differently. We just want to discourage commercial espionage, basically. We want people to compete in the marketplace, right? Build a better product, build a better service, build a better company than somebody, and then outcompete them. That's fine. But don't do it by, sneaking into their office and grabbing all their stuff, right? No, that's not how we want the market to work, right? And so that's really where it developed from, and it's sort of this alternative intellectual property that we have, but just some of the dynamics of it, because, for instance, it can last forever. It can cover a lot more than just a real novel technology. It really has a place in most businesses. And I was talking about the difference about making a choice between patent and trademark. You do have to make a choice between patent and trademark with respect to each particular type of technological advance you might have, right? You're either going to get patent protection on this or you're going to get trade secret protection. However, that doesn't mean you can't use both in your business, right? So you may have certain technologies. All right, I'm going to patent this, but this other thing over here is our trade secret, right? And that's totally fine to do. So I didn't want to give the impression that it's a full-on choice in all respects, because you just may have different subject matter covered under each.
No, that's very interesting. You can trade secret just a part of it, but patent the others so people can't steal this. I find that very interesting. So, Mark, is there any last advice you want to give someone trying to make this decision for the first time? How do they know which route is right for them?
Most important thing is to think about if themselves as being an evil infringer, copier that wants to take that idea and run with it. And if you could buy the product or use other publicly available information or sign up for the service, whatever you're doing, if you could do that and copy everything, like we talked about with buying a bottle of Coke and figuring out how it works, you need to do a patent, right? But if you don't think they could, trade secret's a really good option that you should really consider, right? You don't have to pay thousands of dollars to Mark Goodman or another patent attorney to file a patent application. You might want some service though on getting good advice on how to structure this, like we talked about earlier in the podcast, and getting NDAs drafted. It's a lot less expensive than a patent application. So you have lower upfront cost on this thing, and it can last forever. So it can be a good option. But again, just you have to think about the type of innovation. If it's a mechanical widget, no chance, right? But if it's some sort of formula or algorithm or way of doing business, let's have the conversation.
Nice. Nice. Well, thank you again, Mark. And thanks for joining us for Inherently Distinctive. If you're unsure whether a patent or a trade secret is a smarter route, visit goodmanlawnevada.com to connect with Mark and get clear guidance. And as always, don't forget to like, subscribe, and share this episode with your fellow inventors. What they're going to do, Mark?
They're going to smash the subscribe button, right?
Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.